All right, guys. Sorry I'm a little late here, but we're going to go over this motion that just came out. So they filed a motion for summary judgment, Justin and the Wayfarer parties, and some people in the chat here in the last couple of minutes while we were waiting for this have been asking about motion for summary judgment. So there's a little bit of a difference here, and I'm not a lawyer, so I'm not going to be perfect with this. But let me tell you my kind of basic understanding of this. So this judgment on the pleadings, which is what they're asking for, is saying basically based on the story that Blake told in her pleadings, like in her documents, her paperwork, even if we accept all of that as true, assume everything is true, she would still lose based on the law. If you're asking for a summary judgment, it has to come a little bit later. I think they've looked at the actual proof, like the stuff that comes out in discovery, the evidence, and they're saying there's nothing to fight about. So let's kind of end it here. That's my basic understanding. I don't I'm not, like I said, I'm not a lawyer, so I don't have any way to totally verify that what I'm saying is correct. But that is the best way that I know how to explain it. DFJ says, "Is this the third stream today?" Yes, technically it's tomorrow now, so I don't know, but yeah. All right, so let me pull this up. I'm gonna skim over this tonight, guys. I'm gonna skip over a lot of stuff, especially when it comes to the dense legal stuff, and we'll go over this more thoroughly tomorrow, probably, because I have a stream with a bunch of other people, including Leanne and Cassidy, where we can talk about that stuff. And also, I'll get Omar back in here at some point so we can go over it. But I just want to go over kind of like the more interesting parts and see what they had to say here. And anything we skim over, I'll come back to later, just not tonight. So it is already past midnight here. So, all right, let's take a look at this. Plaintiff Blake Lively's second amended complaint asserts 13 causes of action arising from alleged sexual harassment during production of the film It Ends With Us and a subsequent smear campaign allegedly launched in August 2024, concurrently with the film's premiere. As shown below, plaintiff fails to plead cognizable claims under California's FEHA and other California statutes for retaliation under Title VII for defamation per se and false light under either California or New York law, or for civil conspiracy to commit the underlying torts. Lively's claims fail on the following grounds, among others. All right, the first bullet point here is FEHA does not have extraterritorial application, and thus plaintiff's FEHA claims should be dismissed with prejudice. And we talked a lot about that when we were reading the 47.1 motion with Omar earlier today, the extraterritorial stuff. So we're not going to, when we get to that part of this, we're going to skim over a lot of that because we've kind of heard all of it at this point. Lively fails to allege an adverse employment action, a requisite for retaliation claims under FEHA and Title VII. Lively fails to plead a causal link between her complaints of harassment and the alleged smear campaign, as required for retaliation claims under FEHA and Title VII. Specifically, Lively fails to plead temporal proximately between the allegedly, they mean proximity? I don't know. Between the allegedly protected activity and the commencement of the alleged smear campaign or retaliatory purpose. Okay. Lively fails to allege that she exhausted her administrative remedies against It Ends With Us Movie LLC, a predicate for any FEHA claim against It Ends With Us Movie. Lively's defamation claims, the 12th and 14th causes of action, are barred by California's litigation privilege or New York's fair report privilege, whichever law applies, and Lively fails to plead a civil conspiracy, specifically a tort that all defendants were capable of committing. 15th cause of action. All right. And some of this is unfortunately redacted, guys, so we're gonna miss some context here, but that'll probably come out later. So I'm gonna get a sip of water really quick. Give me 1 sec. Okay. The allegations in Miss Lively's second amended complaint. This lawsuit arises from Lively's claim that she was mistreated on the set of the film It Ends With Us during the first phase of production. It was May 2023 to June 2023, and unlawfully retaliated against for reporting sexual harassment that occurred on the set. Filming began in early May 2023. It ends with us movie and Lively through her company, Blake L. I don't know how you say that, Blake L. Doesn't matter, they're both stupid. Entered into an actor's loan-out agreement with It Ends With Us movie for Lively's acting services. Okay. Wayfarer is not a party to the actors' agreement, which provides, and then of course that's the redacted part. So, the film was shot in New Jersey and New York, where Lively resides. Lively first complained about inappropriate behavior in May 2023. On May 26, 2023, Lively told Sony that she wanted to file an HR complaint. Production, May 2023, and... Okay, so I think it means... Okay. Production, and they're missing a word there. May 2023, and was suspended in mid-June 2023. So I guess that must have been when it started. Due to strikes by the Writers Guild and Screen Actors Guild. During that time, May 2023 to June 14th, Lively experienced invasive, unwelcome, unprofessional, and sexually inappropriate behavior. The SAC details the alleged incidents of inappropriate behavior on the set in paragraphs 85 through 109. Before returning to production on November 9th, 2023, Lively presented a list of 17 protections for return to production as a condition of her return to complete the film. The list was intended by Lively to remedy the misconduct that Miss Lively and others had reported earlier that year. On November 15th, the Wayfarer parties agreed to Lively's terms, and on January 19th, the parties executed a contractual rider, incorporating those terms into the unsigned May 2023 Actors Agreement. Wayfarer was not a signatory to the November 2023 rider, which was signed by It Ends With Us movie only. Okay. So just the LLC. On January 4th, 2024, the parties participated in an all-hands meeting in New York where, according to Lively, a plan was approved for implementation of certain protections that will be adhered to for the physical and emotional safety of Miss Lively, her employees, and all cast and crew moving forward. Production resumed on January 5th and concluded on February 9th. Neither the SAC nor its forerunners identify any act of harassment that occurred in the second phase of filming. In fact, on January 14th, Lively assured a cast member, and I don't know who that is, that the inappropriate behavior had been stopped and that it's a professional set and we're getting good work. On the eve of the film's premiere and release, rumors of discord on the set already swirling in the press. I think they missed a word there again. Were already swirling in the press. Okay. Accordingly, on July 31st, the Wayfarer parties contacted a crisis communication specialist to diffuse the negative publicity and protect his reputation as the film's director. So it's got to be Justin, right? On August 2nd, the crisis management team circulated a scenario planning document with a proposed strategy should Lively and her team make her grievances public. So we've seen that beaten to death. Basically, Blake Lively is assuming or asserting, basically, that this scenario planning document was like proof of a smear campaign. And like I was saying to Omar earlier, plenty of people have thought about doing things, planned to do things if they had to go on the defensive, stuff like that. It does not mean that they actually did it. So if you were here earlier, you know the colorful example that I used, but I'm not going to repeat it right now. So, all right. Okay, so somebody remembers. Vroom, vroom. That's right. Okay. Lively contends that this was the launch of a smear campaign, and that in the weeks and months that followed, the Wayfarer parties engaged in a sophisticated, coordinated, and well-financed retaliation plan. According to Lively, the defendants mounted a well-funded retaliation campaign that sought to bury and destroy anyone that challenged Mr. Baldoni's brand. Based on these allegations, Lively asserts claims of sexual harassment and retaliation under California and federal law, breach of contract, civil conspiracy, defamation per se, and false light. Okay. We're talking about the standard for judgment on the pleadings. Rule 12C permits any party to move for judgment on the pleadings after the pleadings are closed, but early enough not to delay trial. The standard for a Rule 12C motion is the same as that for a Rule 12B6 motion to dismiss for failure to state a claim. Thus, judgment on the pleadings is appropriate where, with all reasonable inferences drawn in favor of the moving party, so like assuming that everything Blake said or her claims are true, The non-moving party has failed to allege facts that would give rise to a plausible claim or defense. Okay. We'll skim over some of this stuff here. Okay. Although a court considering a Rule 12c motion is generally limited to the contents of the complaint, the court may consider the complaint, the answer, any written documents attached to them, and any matter of which the court can take judicial notice for the background of the case. Also, a complaint is deemed to include materials incorporated in it by reference and documents that, although not incorporated by reference, are integral to the complaint. Okay. FEHA and the other cited California statutes have no extraterritorial application. And so this is something like the extraterritorial stuff is something we talked about a lot earlier. So I won't read too much of this tonight, but plaintiff asserts claims for sexual harassment, retaliation, failure to supervise, and aiding and abetting under California Government Code 12940, FEHA, retaliation under California Labor Code 1102.5, and sexual harassment under California Civil Code 51.9. The threshold question is whether FEHA or the other cited California statutes have extraterritorial application where, as here, the plaintiff is not a California resident, and the discriminatory conduct did not occur in California. So, like, nothing fucking happened in California. But she's trying to use this California law. All right. But like I said, we talked about that a lot earlier with Omar. If you haven't seen that, you can go check it out in the live stream tab. So, all right. We're going to skim over the rest of this section for tonight. Like I said, we'll talk about this more tomorrow with everybody. So, okay. Plaintiff's Title VII and FEHA claims against It Ends With Us movie fail because plaintiff does not plead that she exhausted her administrative remedies. Assuming FEHA applies extraterritorially, which is a big assumption, California Government Code Section 12960B requires that an employee such as plaintiff exhaust her administrative remedies before filing a civil action alleging FEHA violations. Similarly, to assert a claim under Title VII, a plaintiff may bring a suit in federal court only if she has filed a timely complaint and obtained a right to sue letter. Okay. On December 20th, 2024, Lively filed complaint with the California CRD against Wayfarer and 10 other defendants and received a right to sue letter for the named parties. It Ends With Us movie, Lively's employer and party to Lively's actor agreement and writer, is not identified in Lively's CRD complaint, and as a result, Lively did not obtain a right to sue letter with respect to It Ends With Us movie. Accordingly, It Ends With Us movie is entitled to dismissal of Lively's 3rd, 4th, 6th, and 7th causes of action. In addition, as more than 300 days have elapsed since the allegedly unlawful employment practice, It Ends With Us movie is entitled to dismissal with prejudice of Lively's 1st and 2nd causes of action. Okay. 6, the complaint fails to state retaliation claims under FEHA or Title VII. The SIC fails to plead an adverse employment action within the scope of FEHA or Title VII. Title VII provides that it shall be unlawful employment practice for an employer to discriminate against any of his employees or applicants for employment because he has opposed any practice made an unlawful employment practice by this subchapter. Okay. To establish a prima facie case under retaliation under Title VII, a plaintiff must show 1, she engaged in protected activity. 2, the employer was aware of the activity. 3, the employer took a materially adverse employment action against her. And 4, a causal connection between the alleged adverse employment action and the protected activity. Okay. California Government Code Section 12940H similarly provides that it is unlawful for an employer to discharge, expel, or otherwise discriminate against any person for complaining of sexual harassment or other discriminatory conduct in the workplace. Retaliation claims under Title VII are broader than under FEHA because FEHA requires an adverse action for purposes of retaliation claim to materially affect. Okay. affect employment, whereas Title VII more broadly defines an adverse action as any action that is reasonably likely to deter employees from making or supporting a charge of discrimination. 1 second, I get some water. Okay. Let's see, we're going to skim over some of this stuff. Lively does not allege that she was terminated, demoted, deprived of any benefit of her employment with It Ends With Us movie, assert any act that may have blocked or interfered with a potential employment opportunity, or other any materially adverse change to the terms of her employment. The SAC includes only 3 cursory references to adverse employment action, each alleging a coordinated campaign to cast Miss Lively in a false light during the publicity and promotion of the film and thereafter. So this delusional smear campaign thing she's come up with may come back to bite her a lot. We'll see. It doesn't seem like she's been able to prove anything, and I believe that's because there's nothing there. You know, if only she had been successful in subpoenaing my bank account, because that's where all the evidence of fucking sexual harassment is, isn't it? What an idiot. Okay. I'm calm. You're calm. It's fine. Lively's claim of an adverse employment action is based solely on the publication of... Oh my God. So I'm sorry. Somebody just left out so many prepositions here. I'm not complaining. Based solely on the publication of negative publicity commencing in August 2024, after production ended and after discord on the set spilled into the public eye. Okay. And there's again, a lot of redacted stuff here, so we can't really see too much of it, but Lively's December 2024 CRD complaint acknowledges that her claims would constitute and then the rest of this is redacted, so. The court should decline plaintiff's invitation to create, and then it's redacted, by creating a new standard for adverse employment actions. Plaintiff's failure to allege an adverse employment action alone defeats plaintiff's ability to establish a prima facie Title VII or FEHA violation sufficient to survive a motion to dismiss. Okay. And then on footnote 4 here, and what are we talking about here? So something about any materially adverse change to the terms of her employment. In footnote 4, it says, the SIC demonstrates quite the opposite. After voicing her complaints, Lively was ceded more control over the editing, not called for in her acting contract, and marketing, and ultimately obtaining an executive producer credit. One might even say that Lively was rewarded after her complaints of inappropriate behavior on the set. Yeah, I would say that, yeah. Oh, man. Let's see. The SAC fails to plausibly plead a causal link between the protected activity and the alleged smear campaign. Okay. So basically, the smear campaign had to be the result of the alleged protected activity. So, like, they had to do the smear campaign because of the sexual harassment and her alleged reports about it. But yeah. Merely pleading an adverse employment action is not enough, and a plaintiff must plausibly allege that the retaliation was a but-for cause of the employer's adverse action. But-for causation does not require proof that retaliation was the only cause of the employer's action, but only that the adverse action would not have occurred in the absence of the retaliatory motive. Okay. One sec. Just trying to turn the slides down real quick. Lively alleges protected activity, complaints of sexual harassment, and a public relations campaign which commenced in early August 2024 at or about the time of the film's August 6th premiere. The complaint, however, does not link the two, much less plead that the public relations campaign would not have occurred absent a retaliatory motive. Simply put, Lively fails to plead causation. Okay. A causal link may be shown by pleading the employer's knowledge that the employee engaged in protected activities and the proximity in time between the protected action and the retaliatory employment decision. A retaliatory purpose can be shown directly or indirectly by timing where the protected activity was followed closely in time by adverse employment action. Okay. We have number 1 here. Plaintiff fails to show the requisite temporal proximity between Lively's complaints and the allegedly retaliatory smear campaign. Okay, so over a year passed between plaintiff's May 2023 complaints and the August 2024 launch of defendant's alleged smear campaign. Got it. Move down to the next one. The SAC lacks factual allegations to directly establish a retaliatory purpose. Okay. The SAC includes 2 cursory allegations of retaliatory intent. One, that the public relations plan was embarked in retaliation for Miss Lively exercising her legally protected right to speak up about misconduct on the set. Okay. And 2, Ms. Abel, Miss Nathan, Wallace and Street Relations, and others employed or engaged by TAG perpetrated a retaliation scheme against Miss Lively in collusion with the Wayfarer parties. This is insufficient to show retaliatory animus or purpose. In fact, the SAC's own allegations show something entirely different, that the alleged smear campaign was not retaliatory, but an effort to defend Baldoni and Wayfarer against the anticipated storm of negative publicity from Lively and her team's blistering criticism of Baldoni and his work as the film's director to coincide with the film's release. And that's definitely true. And we've seen it even in her complaint. You can see that they wanted to defend themselves. Okay, they wanted to do what they could to kind of get rid of the conflict. And they, at all points, tried to keep as much peace as they could. Wayfarer was not, they were a little reluctant to enter into anything with the crisis PR team. And when we saw their messages that Blake Lively obtained in the recent exhibits, you can see that Wayfarer was like, we don't want any theatrics. We don't want any drama. They said, it's okay that people are saying shit about us. Let them. It's okay. Let them. Okay? Because people will, root for the other side and they'll root for us. You just got to let them be. So these people at all turns have been very peaceful. This is ridiculous. So it's all been about defense, and that's it. Okay. Lively cites text messages stolen from Jennifer Abel's phone by Stephanie Jones. I'm glad we're still on that. Okay, good. To support her retaliation claim. These messages do not evidence a retaliatory purpose. To the contrary, they confirm that beginning in late July 2024, after the completion of production and after the end of Lively's acting services, Baldoni and the other Wayfarer parties consulted public relations and crisis management professionals to plan how to counter an anticipated onslaught of negative publicity by Lively about a feud on the It Ends With Us movie set and the struggle over control of the production, editing, and marketing of the film. All right. And they're talking about the text from Justin to Jen that said Ryan had blocked him on social media, saying we should have a plan for if she does the same when the movie comes out. It would be helpful to arm us in the case we need to refute any of the claims. So this is obviously like, we don't want to do this, but if we have to, if this happens, if she does this. Abel briefed press on the situation and stated to Wayfarer that they were armed and ready to take this story of Blake weaponizing feminism. Where's the fucking lie? Okay. On August 2nd, the scenario planning document states, we should be prepared should Miss Lively and her team make her grievances public. So they weren't going to do any of this unless she attacked them and they had to defend themselves. Okay. And then they're citing here where Heath says, that's the most important part of this, is how quickly they can shut things down and place stories in your favor. All right. And then there's an August 4th text from Jen to Melissa Nathan regarding reckless thoughts of wanting to plant pieces this week of how horrible Blake is to work with just to get ahead of it. She's putting us through hell. Dude, come on. We've all told our friends about our weird, intrusive thoughts, especially when you're like frustrated with somebody. This was never supposed to be a thing. Like, they didn't act on that. This was never supposed to be a thing that became public. You're allowed to talk like that to your friends, as long as you don't act on it. All right. August 6th text from Nathan. This will be for creation of social fan engagement to go back and forth with any negative accounts, helping to change narrative and stay on track. Okay. And then we have Abel inquiring about the cost of social media mitigation and proactive fan posting to counter the narrative. Counter the narrative, right. Surrounding Baldoni. Planning for suppressing of negative content about Mr. Baldoni and the amplifying of negative content about Miss Lively. Defendants' concerns proved is it prescient? I don't know how you say that. When on the eve of the August 6th premiere, Lively sidelined Baldoni, instructed cast and crew members to defriend him on social media, and refused to be seen or photographed with Baldoni at the premiere, where Baldoni and his family were banished to the basement until Lively finished her pre-show appearances. Which is a load of fucking bullshit. Okay. The public furor, Baldoni's distress over efforts to cancel him, and Wayfarer's goal to flip the narrative and repair Baldoni's reputation are reflected in the text messages cited in the SAC. There's a text from Abel they're citing that says, "We can't have fans starting to guess why Justin is left out of this stuff," and helping to change the narrative. Okay. They're talking about, the worst is over. Justin likely wouldn't be canceled. There are concerns that threads were appearing on Reddit, speculating about the feud between Blake and Justin. Let's see. On August 10th, a text from Nathan stating that Lively fucked herself by doing the unfollow thing and insisting on no photos together. She totally fucking did, though. She did. Okay. Referencing August 13th text that consisted of drafts of a story outlining Miss Lively's role in making final cuts to the film. And then paragraph 271, article addressed Lively's making final cuts to the film. Paragraph 275, Baldoni stating on August 15th that because of the negative articles, there is no way we can just let this go. He clearly wanted to, but because of the negative articles, not because of a sexual harassment claim, because of the negative articles and because they were attacking him, there is no way we can just let this go. The causation is important. Okay. Thus, what Lively characterizes as a smear campaign began the week of the premiere and was conceived and executed to counter the onslaught of negative press spawned by Lively and her team, quell speculation about an alleged rift between Baldoni and his cast and crew, and explain Baldoni's noticeable absence from joint press events and the lack of group photos at the premiere. Plaintiff, in fact, admits that the plan was not conceived to respond to any particular allegation. It was entirely about managing the public perception that Mr. Baldoni feared might follow the theoretical possibility that Miss Lively might decide to unfollow his social media accounts. All right. Let me drink some water real quick. One sec. All right. Planning to counter potentially negative publicity and efforts to defend one's reputation in the face of highly public criticism is not tantamount to a retaliatory adverse employment action, and plaintiff fails to plausibly plead the requisite causal link, either directly or through Baldoni's efforts to manage the fallout from media stories about discord on the film set, and Lively's efforts to sideline Baldoni from the film's production, editing, and marketing. Lively may not like the public criticism. Yeah, that's an understatement, bro. She unleashed, but the SAC is devoid of facts that might show that these efforts to neutralize negative publicity had a retaliatory purpose. Absent a sufficient factual basis, the SAC's conclusory allegations of retaliation failed to establish a prima facie showing that Lively's sexual harassment complaint were the but-for cause of the smear campaign as required to plead violations of Title VII or FEHA. Okay. 7. Plaintiff fails to state cognizable defamation claims. All right. Defamation requires a publication that is false, defamatory, unprivileged, and has a tendency to injure or cause special damage. The same requirements apply to false light claims. And we've read a lot about her claims on this, so I'm going to skim over some of it. Let's see. And this is just talking about privilege for statements made in the course of judicial proceedings. So that can't be defamatory. Plaintiff's defamation per se and false light claims should be dismissed with prejudice. All right. B, New York does not recognize a claim for false light based on privacy, and the allegedly defamatory statements are privileged under New York law. So again, I don't think we have to really read too much into that right now. Okay. Then we have Section 8, plaintiff's civil conspiracy claim fails. All right. Civil conspiracy is not an independent tort, and its only purpose is to extend liability beyond the primary wrongdoer to other tortfeasors. I've never seen that word in my life. Tortfeasors. Okay. For all damages ensuing from the wrong, irrespective of whether or not he was a direct actor and regardless of the degree of his activity. Okay. To establish a claim of civil conspiracy under either California or New York law, a plaintiff must plead an underlying tort that the alleged conspirators are capable of committing. Tort liability arising from a conspiracy presupposes that the co-conspirator is legally capable of committing the tort. For example, that he or she owes a duty to plaintiff recognized by law and is potentially subject to liability for breach of that duty. Okay. If a privilege applies to the underlying claims, the privilege extends to obviate a conspiracy to commit the immunized underlying claims. Thus, where the underlying wrongs are privileged, the immunity applies to all conspirators. Okay. Plaintiff's pleading of a civil conspiracy is less than precise, relying solely on the conclusory allegation that each defendant committed numerous wrongful, unlawful, and tortious acts pursuant to defendant's common plan, design, or agreement. The SAC leaves defendants and the court in the dark as to who conspired with whom to commit what tort. For instance, as only an employer is liable for FEHA retaliation claims, the non-employer defendants, Baldoni, Heath, Sarowitz, Nathan, Abel, Tagg, and Wallace, have no duty not to retaliate, and thus cannot be liable for conspiring to retaliate against Lively. As explained above, plaintiffs' claims under FEHA, Labor Code 1102.5, Civil Code 51.9, and Title VII retaliation claims fail, as do plaintiffs' and Title VII retaliation claims. Okay. Defendants cannot conspire to commit torts that are not actionable, nor can defendants have conspired to defame Lively as her underlying claims are privileged. The privilege which immunizes the named defendants also immunizes alleged co-conspirators. Also, the SAC is bereft of any allegation that Abel, Nathan, Wallace, and Tagg were involved in the production of the film when the alleged harassment occurred on the set. Therefore, they could not, under any stretch of the imagination, be liable for the harassment or retroactively conspiring to harass Lively. Finally, Civil Code Section 51.9 applies only to those in a business or professional relationship with Lively. The SAC does not allege that Nathan, Abel, Tagg, and Wallace had any duty to Lively arising from a professional relationship, and thus these parties cannot be liable for conspiring to violate Section 51.9. These are only a sampling of the shortcomings in plaintiffs' efforts to plausibly plead of civil conspiracy against 10 defendants to commit no fewer than 11 torts and 2 breaches of contract. Okay. 1 sec. All right. The conclusion here is that for the foregoing reasons, defendants respectfully request that the court enter order granting this motion and dismissing the 2nd through 7th and 12th through 15th causes of action with prejudice. And that's Ellen Garofalo. So Cassidy's going to be happy about that. Like I said, guys, I'll go over this more with everybody tomorrow. We're supposed to, I think it's like 5 Eastern or something. But double check with Leanne's Twitter account to see when that's happening. We're all going to be together for a little bit. I'm not going to be able to stay for too long tomorrow, but I'm sure we'll go over this. So thanks, everybody. Appreciate it. And I got to get to bed because it is almost 1 o'clock in the morning. So let me know what you guys think in the comments, and I'll see you all very soon. Wait, let me read these real quick. Tay and Moon, thank you for the $20 super sticker. I appreciate you. Oh man, you guys are awesome. Angela Zontek, thank you for 25. Thanks for the late update. Well, thank you for this. I appreciate it. It's very helpful. So, especially with the like Kim says here, the Pacer fees. So, it's Kim. Thank you for the Pacer bucks because I'm assuming this is a lot. Man, I guess I do have another bill coming up next month, huh? So I got to check on that, see how it's going. Hopefully it's not as much as the last couple. But I've been slowing down a lot on the Pacer bill. Not, done with it, but It's probably, I'm going to say hopefully it's under 1,000 this time. So we'll see. All right. Thanks, everybody. Appreciate it. And I will see you guys very soon. Bye.